welcome everyone to the latest episode of the 121% podcast, joined today by Andrew Doyle with Seibane Doyle PLLC, law firm here in Central Florida, focusing on business and real estate law. So tell us a little bit about your background, Andrew.
Originally from South Florida, came up here to go to UCF. Originally a micromolecular biology major. That didn't work. Hated chemistry. Decided to get into the law. Picked up on the trial team, fell in love with trial law, trained in college, trained in law school, graduated, worked in real estate for a little bit. My wife is a real estate agent. She's primarily in the secondary mortgage market. Learned a ton about real estate and business at that level, working with investors. And real estate and business law was the natural progression there. So that's where we're at.
I did not know about the whole micro.
Oh, yeah.
That's a new discovery for me.
Yeah. The funny thing is, I hated chemistry when I was in college. Now, I'm infatuated. I'm one of those people that will like Wikipedia something at like 2 o'clock in the morning when I can't sleep, just to kind of learn a little bit about it. So I hated organic chem back in like 2004. Now I read it at 2 o'clock in the morning when I got nothing better to do.
Because you have so much free time.
Yes. Well, I mean, no, it's because I can't sleep.
You can't sleep. So instead of searching law, you're searching something that's not law.
Yeah.
I know I've had some great conversations with you. I love your mind and how you process things and how thorough and detailed you are. It's been a great relationship working with you over the past couple years, and we get a lot of comments and questions and on independent contractor status, which most real estate agents out there are having an independent contractor relationship with their broker. And there's always this big, I call it the battle between the broker and the agent. What can the broker require, versus what the broker can't require. So I thought we could dive into a little bit about that type of a relationship and then how it applies to real estate. And one of the confusing elements that gets people all twisted is, from the DBPR's perspective, they refer to your broker as your employing broker. But yet it's not an employee-employer relationship per se, as we commonly would think of it, where it's a W-2. It's a 1099 independent contractor.
Right. So, I think that this discussion probably needs to start from the perspective of what is an employee, what is a contractor, what is a broker, what is an agent, and how do those two relate? So in business, particularly in real estate, you have this principal-agent relationship. The principal is the broker, the owner, the person at the top, so to speak, and then they employ what are known as independent contractors. Now, getting into whether someone is a W-2'd employee is a tax designation, i.e. that their employer withholds payroll taxes and other from the wages that they get paid. Compare that to an independent contractor relationship, where generally that person will declare their income on a 1099, and then they have an opportunity to deduct business expenses that are associated with earning that income. So it's important to look at this W-2 1099 independent broker situation from an IRS perspective. Caveat here, I hate tax law. I hate it. I can't describe to you how much I hate it. I don't do tax law, so anyone listening out there, I'm not a tax attorney. Confirm what I have to say here with your CPA and or a tax specialist. But this is pretty rudimentary stuff, so I'm comfortable at least talking about it at this level.
Right.
That said, when you look at it from a tax perspective, it makes a lot more sense. A 1099 contractor has write-offs because they're essentially their own business. They are a business that has been employed by another business. This is important, and it helps things kind of fall into place, because in many situations, brokers will employ agents who spin up their own LLC or their own PA for tax purposes. That serves two reasons. One, that helps them legitimize their otherwise presumably legitimate tax deductions, but it also further solidifies that independent contractor relationship. Now that we have the kind of boring tax stuff out of the way, we can shift to how someone is really characterized as an independent contractor. In Florida, and by the way, feel free to interrupt. I can just ramble.
Oh, no, you're good. They hear enough of me normally, so it's nice.
In Florida, it's usually done based on any one of a series of different tests. And running the risk of boring the listeners with all of the different tests, they really state the same thing in a number of series of different ways. And basically, they all come down on this idea of control and custody and the ability to manage someone's schedule and the link, the nexus, so to speak, between the potential contractor and the principal. So, for example, telling someone they must show up at the office at 9 a.m. Monday through Friday, that's pretty specific. That means that the alleged contractor must be in a physical place at a particular time for a particular duration of time. Well, that's what people do with their employees. You work standard hours. So then that something like that brings into question whether or not this person is properly characterized as an independent contractor. The reason why the tests are important is because the tests are multi-factor. It's not one determining factor. It's a series that a court will consider in determining whether or not someone is properly characterized as a contractor. So perhaps there is a lot of control over the schedule, but perhaps they're only paid on a per project basis. Now, applying that to real estate, we have agents and brokers. Agents generally have a lot of control over their schedule. They generally don't have to physically be in the office at any particular time, and they only get paid if the property closes. So it therefore makes sense that they are properly characterized as a contractor. So that's pretty much, I think, a good starting point for this discussion. That's why we're at where we're at in the industry.
So where are the limits? So in a typical, you have some brokerages out there that employ their agents, like Redfin, for example. They employ their agents, so they're W-2 employees. For a typical relationship between a broker and an agent, where is the limit of what a broker can do in control perspective, like minimum training standards or sales meeting attendance, that type of stuff?
So I'd say that definiteness is the broker's enemy in this situation. A broker that places any series of definitive, clear-cut, very specific requirements. Now, requirements for employment are different than office policies.
Right.
So saying, if I hire you, for example, in an offer letter, I'm hiring you as a contractor, but you must be physically in the office from 9 to 5, making calls at least 3 days a week physically from our office, or even physically from your home. These days, with everyone working remote, it's still that concept of control. So, speaking with absolute certainty and being overly specific can definitely expose the broker to a weakness in the defense to an argument that this person is in fact a contractor. And, I didn't cover this earlier, but maybe it's perhaps important. The reason why a broker would not want an agent to be characterized as a contractor, as an employee, comes down to liability. If a broker employs an agent as an independent contractor, then that broker is not by default responsible for everything that contractor does. Whereas with an employee, there's this theory in the law known as respondeat superior, which is Latin for, I don't know what it's Latin for. I can tell you that the second word is Latin for superior.
Right.
It's essentially, it's vicarious liability. It means that the principal is going to be responsible for all of the acts and occurrences of the employee while that employee was acting within the scope of his or her employment. So it doesn't make you responsible for murdering someone on your off time.
Right.
But if you killed someone in a car accident on your way to an appointment, then yes, there is the argument that the broker would be responsible for the contractor's action. So the point is, the broker doesn't want to overextend him or herself by placing an undue burden or a series of particularly restrictive requirements on the agent, because that could come back to bite that broker in the behind.
Right. So what about like a monthly or a weekly sales meeting? Is that kind of crossing the line because there is that control of, hey, you have to be here at a certain time?
So with the, you could talk to 3 different attorneys and probably get 3 different answers on this. I can tell you the way that I would argue it on both sides. I think that's probably the fairest way I could answer this without giving a specific answer, because I'm a lawyer and I don't give specific answers. Everything is, it depends. It's not black and white, it's gray.
Exactly.
That said, so if I'm representing the broker, this is my argument. My argument is no, that is not impermissible. Why? Because I was smart enough to retain counsel who put that requirement not in your employment documents, but in my policies and procedures, which apply equally to employees and independent contractors. We're in an at-will employment state. You don't have to work for me. There are a great many brokerages out here, many of whom are as good as ours. I'm not forcing you. This isn't slavery or indentured servitude. You're free to leave. You didn't have to be working for a broker that required that, but that is the policy and procedures. Now, that would be a very different story if that was part of the requirement for hire. In other words, the understanding of the parties was such that this agent would not be working on the broker's behalf unless the agent agreed to attend these weekly sales meetings. That implies control.
What about in a situation where you're bringing on someone to the company and maybe there's a voluntary training program or a mentoring program that this independent contractor then opts into, and that voluntary program to participate in it has some minimum requirements, i.e. attending a mentor session every week or having, coming to certain script practice, that type of thing. How does that voluntary opt-in impact, or does it?
So I think you hit the nail on the head there. It's the word voluntary. It's not a broker requirement. Because it's voluntary, that's likely subject to a separate written agreement, probably stating, whatever terms and conditions apply to that voluntary opt-in program. In my opinion, it would come down to simple contract law. Was there sufficient definite terms between the broker and the agent as it relates to the voluntary program? And was there some exchange of value there that promise, i.e. that the agent's promise to partake in the voluntary program was subject to any of these other restrictions? So basically it becomes a separate little contract within the arrangement. And the consideration, which is the exchange of value that's key to any contractual relationship, that would probably have something to do with an increase or a decrease in the amount of commission that agent was entitled to receive after completion of the program.
Okay. The other thing that we hear a lot about is brokerages that require minimum production. So at the end of a year, you have to have, say, 6 transactions or 8 transactions, a number. And I've heard arguments from both sides that say, well, because you're requiring minimum production, that requires minimum work effort, therefore it violates ICA. But then it kind of conflicts with the requirement of a broker. I'm going to speak specifically to Florida, where the Florida Real Estate Commission says I'm responsible for this agent in making sure that they're doing what they need to be doing and making sure they're complying with the law. So in order to be proficient in your craft, you need to actually do your craft. That's with anything, right? So what's the balance there?
I'm going to answer that with an opinion.
Okay.
Okay. And spoiler alert, I represent brokers more often than I do agents against their brokers. I think that the issue there is really this. I as a broker, do I need to keep you on if you don't produce? What do I get out of the relationship? Because an agent that doesn't produce, an agent that doesn't close, is liability, and really not much more. Now, it's a different situation if we're talking about an agent who is aggressively pursuing, and for whatever reason, bad market conditions, just bad luck, poor quality leads, just can't generate. That's different. But that's also not the type of agent that a broker wants to get rid of.
Right.
So really, we're talking about a situation here where you have a broker with an agent that just isn't producing because the agent probably isn't trying hard enough or isn't thinking outside the box, isn't getting creative here. And that's really a liability to the broker. So the answer to that question would be, I don't have a problem with minimum production values in an independent contractor relationship, because I think it cuts to the key of the relationship, the core of the relationship, which is I, as a broker, supervise and train you, and I oversee your production. You close, and the checks come to the brokerage, and then you get your agreed upon commission. If no checks come in, then it's just costing me money, risk, time, stuff like that.
Yeah, I mean, a lot of agents think that there's no expense to having a broker, to the broker, I should say.
No.
And there is. I mean, there's the added cost. A lot of stuff is paid per agent, not per closing, for the technology platforms and those solutions.
Which, by the way, is kind of the key, the reason, the explanation, justification behind charging. Some brokerages will charge these E&O processing fees per transaction to the agent, things like that. That's why, because at some level that brokerage can, justify that with a metric of, this is my annual cost to employ this agent employ is a bad word, dirty word, to retain this agent and permit this agent to work in the brokerage as a contractor. This is the cost to me. But you're spot on. There's a significant cost, and the cost is greater when you're dealing with an agent who doesn't produce.
Right. What about like minimum standards, minimum quality standards, whether it be paperwork being turned in on time or dress code, that type of stuff? How does, again, like as an employee, you can mandate when you come to work, you're going to follow this dress code. Mm-hmm. But how does that work if, you have independent contractors?
I don't know. Well, I mean, I know, but I'm thinking. So for whatever reason, this thought just came to mind. I don't work for the court. I don't have any employment relationship with the court. I'm an attorney, and I show up, and I go to a judge's hearing. These days, I'm usually in my office, but I'm virtually in the judge's hearing room. But there's a fair amount of control over my conduct, the way that I look, what I have to say, what I can't say, what I should say, how I appear, my demeanor. So I think there's some value to that corollary here. Now, putting that to the side for just a second and getting back to that, to your point, there are concerns that relate to dress code, standards for workplace behavior and conduct that really don't speak to the employer-employee relationship, the principal-contractor relationship. Whether you are working as a contractor or as an employee, it's illegal to discriminate. Mm-hmm. It is illegal to harass someone. These are legitimate issues that have nothing to do with how you're getting paid and who's paying your payroll taxes. So, yet again, representing brokers, I would take what I think is the compelling position, which is that doesn't matter. These are the office policies. Now, at the same time, you don't need to put in writing that you can't commit sexual harassment or gender discrimination when you go to work. Right. That's already a crime. Well, it's not a crime. Yeah, obviously I'm a civil attorney. I'm not a criminal attorney. Otherwise, I would have known not to use that word. Go ahead.
Violation.
Violation, yeah.
Yeah, that's what I would call it.
Yeah, basis of a civil suit.
Right. Because that's one of the things is you're trying as a broker, and also speaking as a broker, and someone who I try to focus and be agent-centric, is that you're always trying to find the balance between protecting the brokerage on behalf of all the agents. Right. Because if you have one agent out there doing inappropriate things or going outside the lines of the law, that's a negative impact on the rest of the team. We are all one as a brokerage. So you're trying to balance that with the independent contractor status, also with the requirements of the commission in your state. So it's just this delicate dance. I feel like, at any point you want to be pro-agent. You want to make sure that they have the freedoms to do what they want to do, to build their business, but within guardrails. And that's why I use my head, like, here's your road and here's the guardrails you need to stay within. Mm-hmm. Yeah. But making sure those guardrails don't violate any law with regard to the independent contractor status.
Yeah, no, absolutely. Just to kind of circle back to something, you just hit the nail on the head. You said it's a broker's job, so to speak, to make sure that the agent can build their business. Well, that right there is one of the key factors in determining whether or not someone is an independent contractor or not. Do they have a separate business within a business? Again, this is why so many agents will create their own PA, and that's why their share of the commission will be paid to that PA. It's a business within a business, and in the independent contractor, with the broker contractor relationship, it really needs to be treated like that, a business within a business.
Right. But then even within we're a franchise. We also have rules we have to follow and guidelines we have to stay in. We're a business within the larger franchise. Yeah. So it's a very interesting balance. And the issue with it is, as you said, you talk to 3 different attorneys, you get 3 different opinions, which then you go, well, as a broker or as an agent, what the hell? Like, do we flip the coin of where we go? And of the attorneys I've talked to, of course, I trust you the most, which is why.
Well, I appreciate that, but you also got to remember, I tend to represent businesses. If you were to speak to an employee litigation attorney, an employee employment litigation attorney, someone who primarily represents employees against employers, they're going to say never in a million years. Mm-hmm. And if you speak to someone who does exclusively employment law representing businesses, they're going to say, oh, absolutely. Never is there that's the position that they're going to take just because that's what it is. What I do is represent the business, and my job is usually to make these cost-benefit analysis decisions with clients and say, look, is this juice really worth the squeeze? And that's an important point here. In any sort of employment, let's keep it focused on this. In any sort of independent contractor, broker, agent dispute over commissions and everything like that, it's easy for emotions to get high, right? It's easy for a broker to be offended when the agent doesn't show up to the otherwise mandatory sales meetings, or it's very easy for the agent to be offended when they're told that they have to be somewhere. And this can very quickly snowball. At the end of the day, I think it's really important for both parties. So whether you're an agent listening to this call or you're another broker trying to inform yourself, it's all about how does that move the needle? Are we any better or worse in our relationship? Because our relationship is purely transactional. It's financial based. That's what it is. I mean, unless you're talking about employing family and friends and things like that. But presumably, it's a financial relationship. That's what it is. I have a business, and my business allows you to make money. And you are making money by selling properties or helping buyers purchase properties from within the brokerage. So if you can kind of keep it focused on that, regardless of what side of the V, so to speak, you are on, and just really focus on the practical, not the principle. Anyone who's ever consulted with me has heard me say practical versus principle before. It's so important not to be fighting over things over principle.
Right. Oh.
Yeah.
It's easy for you to say as the attorney who you're involved in. Like for us, it's a little bit, sometimes like you want to fight for the principle of the matter, and it's tough.
But, an attorney's not a hired gun, or at least an attorney shouldn't be a hired gun. An attorney should first be an advisor. And it's never advisable for someone to spend a whole bunch of money to fight something, even if they're going to win. If it's going to cost you more to win, you're only fighting on principle. And if you want a piece of paper that says that you were right that badly, okay, great.
One expensive piece of paper.
Yeah, it's one very expensive piece of paper. And these situations, independent contractor agreements where, parties take the position, they bring in employment counsel, and brokers get demand letters from employee litigation attorneys. It can get very expensive very quickly, which is why I think it behooves everyone, whether you're an agent or a broker, if you have an issue here, you really need to approach this with a cool head. If you're an agent and you think that you're being pressed to do things that legally you're not required to do by your broker and you take issue with it, certainly by all means seek the advice of counsel. But at the same time, you should try to come to terms with your broker first. And if you're a broker and you have one agent of 100 that raises this issue, then it's probably an outlier. But if you are a broker and you have multiple agents coming to you over time, then it's probably a shared sentiment, and you should probably consider maybe lightening up a little bit,
Right.
because there's value in having a calm culture to your business.
Well, you also want agents that are affiliated with you that like being affiliated with your office because, as I tell our agents, I try to tell the brokers, stop being so damn broker-centric. Your agents can fire you at any time by simply moving their license to another brokerage.
Yeah.
It's that easy. When someone moves their license, I don't get a notification from the state. It's just done.
You don't?
No. So we know because they took the time to tell us, or we do a weekly audit just to make sure everybody's license is in good standing, nothing popped up. And that's how we'll find out, like, wait, we have one less number on the state website than we have.
See, I kind of, for what it's worth, I kind of feel like that's just something that in 2021, the DBPR should have.
You get an email when you bring on a new agent, but you don't get one when they separate within the state of Florida on my Florida license.
Wow.
Yeah. So with them being able to fire you at any time, it's so important that especially in this day and age, it's so easy to move, right? Make sure that you are building a sound business that's fair, that respects and values everyone, and it's a good equal relationship between the agent and the broker. If we're both stronger, we're stronger together. It doesn't work if the broker's strong and the agent's weak, or vice versa.
Right.
It has to be a good match.
Right.
And too many agents focus on, they want the strength and they want the broker to be weak, and too many brokers focus on the opposite. Which is why we opened our brokerage 5 years ago. Was that, as much as I love my old broker, I wanted an office that was putting the agents first. How about asking the agents what type of training they want? If you have attendance issues at meetings and at trainings, you shouldn't have to make them mandatory. They should want to come. So if they're not showing up, reevaluate what you're doing to get them involved.
Yeah. What's interesting is that, correct me if I'm wrong, you probably know this a little bit better than I, but I think it's 2 years, right? 2 years of license activity as an agent, as a sales associate, before you're eligible to take the exam for a broker.
It's 24 months of having your license active with a broker.
Right.
No production required.
Right. So it's really just a waiting period of time. So, if you're an agent and you have so much issue with your broker imposing these obligations on you, it's a 2-year period of time before you can go out there and do it yourself. Granted, there's a significant amount of risk, and I would venture to say that an agent that takes issue with his or her broker's, the way that his or her broker runs their business and is placing these obligations on them, probably will change his or her tune when the tables are turned and that person then becomes the broker, because he or she will certainly want to see the people working under them, perhaps exposing them to liability, will definitely want to see them falling in line consistent with brand and business standards.
It's scary when you find out you had an agent that did something that they shouldn't have. We've had it happen twice now. And both times we parted ways because they were pretty big ones. And it keeps you up at night because you care. So, and then if you're an agent and your broker's doing something they shouldn't be doing, that's a reflection on you as well, because you're affiliated with that office.
Absolutely.
So it's so important that everybody just, talk to each other and communicate, and it's a good world. So we talked about a lot of stuff. So minimum production. I don't think there's anything else from an agent broker relationship that I've heard of. I think that's about it.
I mean, I think the last thing that I would like to talk about is the need for this relationship and the terms to be in writing. Text messaging ain't going to cut it. It needs to be as formal as possible, as clear as possible, not written on a napkin. These commission disputes, brokerages these days, there are all sorts of different commission schedules. There's a sliding commission based on production. There's, based on total sales volume, percentage, bonus, all sorts of stuff. And because it's such kind of a loose contractor relationship, you can play around with that. You can't do that with an employee that shows up 8 hours a day and gets paid X number of dollars an hour. And that's perfectly fine and acceptable, but that really needs to be in writing.
Yep.
So brokers, make sure that you have really clear independent contractor agreements. And I guess to bring things full circle, if you want to impose these office policies to protect yourself and to make sure that people are not diluting your brand and your agents are out there doing the right thing, representing your brokerage, you should also consider incorporating what I call P&Ps, policies and procedures. Very important separate document. Usually when I draft those, I make sure to reference those in both the independent contractor agreement, incorporate them by reference, and then the other way around, so that they're kind of inextricably intertwined and interpreted alongside one another in any litigation scenario. And if you're an agent, you would want that in writing too, because if you're getting railroaded by your broker, you want a document to go back to. You don't want a text message.
It baffles me in real estate as an agent, and I still see as a broker, we'll send out a 25-page contract packet to a buyer to put an offer in a house. And in a minute and a half, you have it back with 3 signatures from 3 buyers, right?
Oh, wow.
You know,
okay.
It's bam, 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 but no one reads them. And the same thing happens with agents. It blows my mind. We pull it up on the big screen here. We do everything digitally, so it's not paper. And as soon as they sign, everybody gets a copy. But how many agents put their signature to our document without reading it? And then and there are, unfortunately, brokers out there that might have stuff hidden.
You know what the great irony of that is? I never receive something I don't read. And I'm always reading something I've read before. How ironic is that? Like I write these documents and I argue about these documents for a living. And every time someone gives me something, I read every word of it. Now, granted, that's my job. But at the same time, I know what's in there. My gut kind of tells me what it's all about. But I still read every single word. And very rarely do I ever catch a trick or anything like that. Sometimes, okay, fine. But the reality of it is these are usually standard documents. And I'm a lawyer that's retained by buyers and sellers, agents and brokers, so on and so forth, to enforce the terms of standard documents that I've read I don't know how many times. But I read every single word. Why then, if you are signing an independent contractor agreement, a contract to purchase a home for hundreds of thousands, millions of dollars, not read every single word, or at least not hire an attorney to tell you what every single word means? That boggles my mind.
It blows my mind away. Yeah. You know, and you know, I mean, you've read our contract. We try to make it a very balanced contract. You know, we outlined if you leave the brokerage, this is how you're going to be paid for any pending deals. You know, all of that's laid out in clear terms, so that way there is no confusion. And then, so I mean, agents read it, make sure you understand it, ask questions if you don't, and then understand that the broker is going to enforce the terms of the contract, and you should want to enforce the terms on the broker as well. It's you're taking the time to have this document. You want to make sure that everybody's following it.
Absolutely.
You know, we just had a situation where someone's upset because we're enforcing a term, and I'm like, we all agreed to this. We agreed to it. Do you remember agreeing to this? Yes. Okay. Right? We're not going to make one-off exceptions for this person and then not that person, because once you open Pandora's box, you start going down a rabbit hole that's very dangerous.
Yep, absolutely.
And that's, you know, for us here at our office, we have one comp plan for all.
You have one what?
One compensation plan.
Oh, yeah.
There's no side deals. It's on our website. Go look at it, right?
Yeah.
And I did that because there were, you know, there's a lot of brokerages that have these side deals. Well, I'll do this just for you. Well, why did you do it just for that one person? That person was white, but this person was Hispanic, and you didn't.
Right.
So then you start getting down a rabbit hole that's dangerous.
Absolutely, absolutely. I mean, at the same time, though, as a franchise brokerage, attorneys, by the way, that are far smarter than I, came up with those standard comp packages, I presume. You know, I guess my point is it's a lot easier of a position to take when you're one of those larger franchise brokerages than if you are a smaller brokerage that has, you know, just one guy or one woman broker with a handful of agents, and they understand the intricacies of why one agent should get more than the other. perhaps. I mean, I'm hoping that there are brokerages out there that do those side deals that you mentioned, and they have good justification. If they don't,
Hopefully it's in
then,
writing.
yeah. You know, if they don't, then I do agree. Facially, there could be problems.
Yeah. So that's all. Any other final thoughts before we wrap up for the day?
No, I'll just hammer this home. Everything needs to be in writing.
Yes.
Yeah.
No, don't put anything emails and put it into a document, have everybody sign it so that it's, I always, one thing I learned from you is that in any situation, you don't want to go before a judge. Not that we've had to, thank God. Put that out there, no assumptions out there. But you don't want to go before a judge and have a lot open to interpretation or viewpoints. Have it spelled out clear as day so that you're hedging your bets that you're going to get an enforcement that favors you.
Yeah. I mean, brokers that come to me and have me draft any document, dollars to donuts, is going to be twice as long as another attorney. It's not necessarily better. It's just how I write. I like to look into my non-existent legal crystal ball and try to foresee the future and anticipate every possible scenario. I never can, but I really do try to go that deep into the business and say, okay, well, what if this happens? What do you do in these situations? Oh, okay, then we should have a clause for that. It may not be something that's customarily standard, and it may not even be anything that's ever an issue. But yeah, that document should be as detailed as possible so that, you've heard me say this before, I love being in front of a judge and saying, Judge, I'm glad you mentioned it. It's right here, section 4, subsection 3.2, right there, plain language. There you go. We already addressed this.
Yep. It's important. So brokers, make sure you're talking to your attorneys, agents, read your independent contract agreements, get an attorney to review it if you want to. But make sure you read the darn documents. I can't stress that enough. And then have open dialogue, both parties, brokers and agents. If there's an issue or you're concerned about something, agents don't just depart the brokerage. Go sit down and have a conversation. Dialogue is best. Have just a professional conversation. If you can't work it out, then some people are meant to be married and some people are meant just to be friends. So it's okay. And that's why I tell agents, for us, you can leave at any time. We're not going to hold your commissions hostage because if I can't make you happy, and I'll do everything I can, I want you to be happy. If that's with someone else, then go date someone else. We're good at that. It works. So any other final thoughts? No,
just thank you so much for having me come here today and talk about the wonderful world of independent contractors.
And if someone's in Florida and they're looking for the most amazing business and real estate attorney in the state of Florida, want to share your contact information?
Yeah, Seibane Doyle. Check us out on Instagram at Orlando Lawyers. I'll leave you with this parting image. I'm a terrible dancer with no rhythm at all whatsoever.
I've noticed. It's on Instagram.
My wife, who is my law partner, is a fantastic salsa dancer with an amazing amount of rhythm. So to her, these TikTok dances come natural. To me, it's like being caught in a paper bag. Anyway, at Orlando Lawyers, you'll see me do a whole bunch of self-deprecating and embarrassing dances, but hopefully you'll also learn a bunch. We try to make our Instagram page a resource for agents everywhere.
And it's really good. It's definitely really good. And we'll put all of his contact information for the office in the description below on YouTube, as well as in the show notes on your favorite podcast app. So thank you so much for watching. If you are on YouTube, do us a big favor and hit that subscribe button, and then make sure you press the bell notification, give the video a like so that you'll be notified whenever we release new videos. And don't forget, only the best, give it 121% and push that subscribe button and that bell. So please do it if you're on a podcast app, Apple, Google, Spotify, and Stitcher. Please do us a favor, leave us that 5-star review. Helps the algorithm, helps get our podcast in front of more people so we can help more agents and help more brokers grow their business. Thank you so much for listening and for watching. Go out there every day, defy mediocrity, and deliver those extraordinary experiences. Bye-bye.